All right, these are statements that have come in from the country's law minister. The Union Law Minister Kiren Rijiju told Rajya Sabha that a constitutional body like Supreme Court should not be hearing bail applications and frivolous PILs at a time when pendency of cases is so high. That statement of his has caused quite a bit of ruckus. We'll go into exactly what the ruckus was, but Rijiju introduced the bill to rename the New Delhi International Arbitration Centre and that was actually passed by a voice vote, but he also was responding to allegations made by various opposition members. In that, he made these statements. Let's go over to my colleague Arunima right now to understand more. Arunima, could you just break down for our audiences what does Rijiju mean when he says that pendency is so high that the Supreme Court should not be focusing on these issues? And could you also tell us how the opposition responded?
Let me begin by giving you the exact quote. He was responding in this matter of an arbitration bill that government has brought in. This was an arbitration bill whereby the name of New Delhi International Arbitration Centre Amendment Bill 2022 was brought in. It was an international arbitration platform bill. And during the course of his reply, after all the opposition members had made their remark on this bill, Kiren Rijiju said that we are all concerned about the number of pendency that are there in the higher court. He said if Supreme Court of India starts hearing bail applications or frivolous PILs, definitely it will add to the burden. Supreme Court is largely seen as a constitutional court, and I have taken this up with judges. Essentially, his case was that you are a constitutional court, you are meant to only hear constitutional matters. If you start hearing PILs and bail pleas, then it will add to the pendency. But Kapil Sibal, senior member of the bar, former law minister himself, has not taken kindly. He said that, Supreme Court is the ultimate custodian of liberty. And how do you get liberty if your bail applications are heard at the highest level? And therefore, to say that SC should not hear bail applications is striking at the very root of the fundamental right that our constitution is given to the citizens.
Okay, Arunima, can I ask you to stay with us? We are going to move on, but we'd like to come back to you. First, though, let's take our audiences to exactly what the Union Law Minister had to say. Take a look.
How much outputs the Indian courts are giving, naming of the high courts. Of course, today's matter is related to the arbitration and naming of the, or renaming of the New Delhi International Arbitration Centre. But I can assure you that government, presently under the leadership of Modi ji, the budgetary allocation, the proactive support to judiciary, this is very well known. No courts in India can say that they are wanting the support of Government of India, especially for infrastructure. Now, most of the pending cases are in the lower courts. Supreme Court has close to 70,000 cases. That too also I have made certain remarks in a very, very good gesture to Honorable Supreme Court that you take up those cases which are relevant and which are appropriate for Supreme Court to take up. If Supreme Court of India starts hearing bail applications, if Supreme Court of India starts hearing all frivolous PILs, definitely it will cause lots of extra burden on the Honorable Court itself. Because Supreme Court by and large is treated as a constitutional court. And I have personally conveyed this message to the Honorable Chief Justice and the other judges of the Supreme Court that we will be with the Supreme Court. We will be the courts of India. We will always be there to ensure that the independence of judiciary is not tinkered around with. We will be always protect the independence of judiciary and also to strengthen the judiciary. But when we talk about cases pending which is touching 5 crore, definitely people ask the question to law minister. And in the parliament many questions come that why so many cases are pending. Now if you see more than 4 crore and 25 lakhs cases are pending in the lower court, where Government of India has a stake. We give money, support to create better infrastructure. But we have to also ask the judiciary that please ensure that the deserving people are given justice and those unnecessary burdens are also taken care of, that they don't cause disturbances while the court is functioning or court is discharging its duties. The main duty of the court is they are the arbitrators. They are the people who are going to deliver justice. But I have always very openly stated that judgment or justice can be given from the ground also. It is not that you deliver justice from the courtrooms alone. You can go out to the field. Judges can also go out of the courtroom and deliver justice. That is why we are talking about mobile courts, Lok Adalat. We are going to the field. I have personally gone to many places along with the Chief Justice of the High Court to ensure that the lower court judges are delivering justice on the ground. I'm extremely delighted that I have seen many instances. So people get excited. Some people get emotional that without requiring to go to the court, the courts have come to our doorsteps. That is called justice at the doorstep of the people. So, sir, government will do everything. But when we talk about holiday being obtained by the judges, how much output a particular high court, a particular judge delivers, these are matter definitely which concerns every citizen of